Can you send me a link, Kathy? To the Zoom? Oh, now it is. Wasn't it? Yeah. Maybe my computer had downloaded. Okay. All right, good morning, everyone. So I'll do we'll do announcements and on this calendar, which is ultimately going to be the trial calendar. What day is it next week, Kathy? The 28th? No, today is the 28th, 31st. Okay. No, I know. Okay. Position 1, Joseph Woods.
He had a final plea on August 14th. I was on leave, so my client had failed to the final. I was going to ask that the case be heard.
See something here.
Leave of absence that I filed for the case.
Yeah, I remember there was something a little off about it. For some reason I wrote, so you are definitely the attorney?
Yes, Your Honor. I think I was appointed in June, and I filed my leave of absence June 29th.
All right. What? Are you? Yeah, unfortunately, it seems like wherever I go, I have to download the software for it. Just want to look this up real quick. When was his final plea date? Oh, the 14th.
Yes, Your Honor.
Yeah, I remember we moved, we moved it to now because I thought, well, we'll just do the final plea today.
I have received an offer from the state. I can discuss that with my client.
Ms. Clark?
Yes, Your Honor. That's correct. He has received an offer from the state. The co-defendant in this case, has been further noticed to the November calendar because of valuation.
Oh,
So I have no issue. He can pre-try if you'd like with his client.
all right. Why don't you pre-try with your client when we take a break? Okay, Mr. Brown?
That's it, Your Honor.
All right, thank you. Okay. Position 2, Gary Chance.
Good morning, Your Honor. Mr. Chance is present. That'll be approved this morning.
Okay. Is that yours, Ms. Clark?
Yes, Your Honor, it is.
Okay. Position 3, Michael King. Pardon me? Oh, 3 and 4. Thank you. 3, 4, and 5, Michael King.
I'm present on that, Your Honor.
What is Mr. King? Is Mr. King present?
Here, Mr. King is present, Your Honor.
Is defendant not here?
Does not appear
Okay.
that,
Your Honor, any question for Uncle?
let me see something here. All right, we'll do a bench warrant and bond forfeiture. Yeah. I guess I guess my question is, how do you know what his correct address is, but the clerk doesn't? Yeah, yeah.
The current address is on top. Current one is
Okay. I feel, no, I was curious why, but I feel like that conversation needs to be had with the person that sends the mail out, but.
They sent it to the wrong.
Eh. All right, well, there's nothing we can do there then. Let's just reset it.
It looks like we updated that.
Pardon me?
He was at the final plea calendar. Recall he left or something without. And you said that if he wasn't here, you were gonna give him a bench warrant.
Let's look them up. Ms. Jones, you have anything to say on it?
Your Honor, he was here at the final plea and he did leave early. I do recall that, Your Honor. However, if notice wasn't properly served on him via the clerk's office, that's not going to be valid service.
Go ahead, Ms. Clark.
Your Honor, the bench warrant is based off of his performance from last time, the fact that he's not here today. And he was aware of the final plea date as well as today's date.
So he left, he just left. That's where, I think I recall that he did leave.
Late afternoon, Your Honor.
That's right. He did just disappear.
And I want to say he might have had kid issues. I'm not sure. I can't say that for certain. And I'm not necessarily sure he knew to come today rather than just Thursday. I'm not sure. I do know that when I talked to some of my clients for today's calendar, they were unaware they were supposed to be here today until I reminded them. And whether or not they got notice, I don't know, or got lost in the mail or went to grandma's house, didn't check it. But I do. He did leave early.
All right. I'm going to do the bench warrant though, for the fact that he left early, not for today, because I do agree that he didn't get proper notice. So. Did we get notice out on time? I mean, I see a bunch of people sitting here, but. I mean, he may have had kid issues or something. I don't know, but you know, at a minimum, he needs to reach out and say, hey, you know, I had kid issues. Don't send a warrant out after me. But that's what I would do at least. Because I don't, believe it or not, I don't actually like doing these, but sometimes it's necessary. Did we, when did these notices go out?
August 1st.
Okay, well, that's obviously enough time. Position 6, Robert Butler.
Morning, Judge. Maya Griggs here on behalf of Mr. Butler, who's present in court. What saith the state?
I'm sorry, I didn't hear that.
What saith the state?
Oh, okay. What saith the state? What saith the state, Ms. Clark?
Your Honor, this is 88 Charles's case. I would ask that you hold for her.
Okay.
I sent her an email as well, Judge. I didn't know if she was going to report, but just to let you know, we've spoken about it. I expected there to be an announcement this morning.
Okay. Position 7, Roderick Davis. Okay.
And Ms. Rockland.
All right. Position 8, Alex Simpson.
Your Honor, I am present on that. My client has mental health issues, and I have discussed with the state last week that my client is now in a mental health hospital. There's a problem with some of his medications, and his treatment provider, as well as him and his family, decided that he needed inpatient treatment. He is still currently there, Your Honor, so there's obviously some competency issues at this point, but we're not going to file anything because I think as soon as they get that medication adjusted, it's going to be good. And they sent me notice or proof that he's in the hospital. I shared that with the state. We've worked out pretty much how we're going to resolve this, Your Honor. Now it's just a matter of getting his mental health status stable. So we would just request this probably be reset till October. And in the meantime, if he does become stable, we're going to be doing a pretrial intervention with him, just to make sure he's staying on his medication, because that's what the state's obvious biggest concern is.
Morning, Judge 88 Matthew Holmes on behalf of the state. And yes, I spoke with Ms. Jones about the situation. What we were going to propose to the court is kind of like a virtual PTI. But part of that requirement is that whatever treatment plan that he is working, because this incident stems from sort of a mental health episode, which is clear from the body cam and speaking with the family as well, that be baked into the parameters of the BPTI order, and then chart him for the next, 3 to 6 months. But if he is still being evaluated for that treatment plan, or that's going to be amended or changed, or medication changes, then I believe that process should probably take place, and then see where he's at afterwards.
He's out of state?
He is, Your Honor. He's in Ohio, I believe, and he has no intentions of ever returning to the Atlanta, Georgia area, which I think is fine with the state. And I think he's got stable housing, and he lives with his grandmother up in Ohio. So it's just a matter of getting him back on his meds and then resolving the case via PTI.
So you want to reset it for 30 days?
I would say a good 30 to 45 days, Your Honor, because they are adjusting his medications, and sometimes it just takes,
Oh, that's right. You said the October calendar.
it takes a little bit of time for them to adjust to the new medications. And I think they might have been talking about switching them, because they just weren't as effective anymore.
Okay, Mr. Holmes, no objection on your part?
No objection.
All right, we'll reset it to October.
Thank you, Judge. That is my only case, Judge.
Okay.
It's going to run over to trial calendar and before Judge Dunaway.
Okay,
Thank you.
you're excused. Position 9, DeMar, is Hornsby Wilson here yet? All right,
Yeah.
yeah, and yeah, hold for Wilson. All right, number 11, Tucker.
I am
Good
present
morning,
on
Your
that.
Yeah.
Your Honor, he knows about this morning.
And Judge bench warrant if he doesn't show up. I'll wait. Well, of course, we're going to wait until the end, but
Okay. All right, well, we'll put it down for a bench warrant bond forfeiture then. Obviously, if he shows up, let me find him on here. Position 12, Porter.
Present on that, Your Honor. I just need to talk to the state, and then we can report back.
Okay,
yes, Judge, we can pre-try that. Yeah.
all right. Position 13, Thomas. That's Brent. Yeah, Wilson called back. Position 14, Hodges.
I am present on that, Your Honor. I spoke with him on Friday and that was going to be a plea. I'm not sure where he's at, but I'll try to call him.
Okay.
Your Honor, ADA talked to the state, we can hold the announcement
All right.
based on Chief Jones.
Position 15, sermons.
So, that was gonna be reset for the calendar. Mr. Sterling is still, in the cab count. On what's that, Friday, the 21st, on Thursday.
Your Honor, I think we're working for the resolution.
Let me look.
That Mr. Sterling and I were in talks, working for the resolution.
So Sterling has when did he file the conflict? Because he's got a murder trial in DeKalb right now. And so Miss Clark, you said you're working on a resolution?
Yes, Your Honor, we're in talks with, for a resolution that will be shorter trial.
Would you say a resolution or a shorter trial?
No, I said, yeah, a resolution that will be shorter trial.
Oh, short of trial. Okay. Okay, I had never heard of a resolution to make a shorter trial, so usually it's one or the other. So Sterling has a conflict murder trial. All right, let's reset it to the next available final plea date.
Ms. Robinson, you said that that's the October. September. Thank you.
Oh, I forgot that Mr. Sermons is in the audience. So what day will that be? So we can tell Mr. Sermons.
Well, that is
All right.
the Monday.
Did you hear that, Mr. Sermons? Monday, September 12th. You'll be back here. You're excused. All right.
Oh, I'm sorry, it's Tuesday. I'm looking at the wrong day. It's Tuesday.
Tuesday, September 12th. Or is it Tuesday, September 3rd? What? Tuesday, September 12th.
Right. I'm
Okay,
sorry.
Tuesday, September 12th. All right. Position 18, Antonio Lewis, that's Hornsby.
Yeah, Judge, good morning, Your Honor. Was under the assumption that this was reset due to a piece of evidence that's missing that I've been trying to track down. I do believe this will be resolved short of trial. I just need some time to get that one piece of evidence, Your Honor.
Give me 1 minute.
Yes, sir.
Well, I'm sure I probably did, where the calendar's disappearing. I'm not doing a good job there.
I believe this was on the 18th calendar
right.
and then got reset then.
So we reset it on the 18th?
That's my understanding, Your Honor. Yeah, because Brandon Lewis, Brandon Wilson came to court and said he didn't have something, and then afterwards, me and him spoke, and there is a piece of evidence that we need to resolve the case that we don't have.
Okay. Okay, we'll reset it then. Not much I can do there. Position 17, Robert Riley.
That's my case, Your Honor. He's present. We've actually never had final plea on this. We were here on June 5th. I think Ms. Iqbal may have been out with something and we were told we were going to be reset. I'm fine if the court just gives me the opportunity today to speak with Ms. Iqbal and see if we can resolve. Otherwise, we'll be ready.
That's fine, Judge. We can pre-trial the case. No worries.
Okay, we'll pre-try it then.
Yeah, he has an offer and everything, Judge.
Or you'll pre-try. I'll
Yeah.
wait. Yeah, and I probably have had this conversation before. Is it really or Riley?
It's Riley, Your Honor.
Okay, so they misspelled position 17. All right.
So we clerk's office spelled it.
All right. In position 19, Walker.
I am present on that, Your Honor. I need to speak with Ms. Iqbal and then
Yeah, Judge, we can pre-try that as well.
make an announcement.
Okay, is Miss Rockwell on yet?
Your Honor, before you go on, position 18, that is Mr. Defendant Riley's case, but Attorney King filed a entry of withdrawal from that case. So I think that was,
Yeah, that one's the public defender's case. My office inadvertently got confused there and filed an entry in the wrong case for us. I've spoken with the public defender on that. They're aware that they're still on that case. I've never been on it other than for 10 minutes when my office filed the entry.
Mr. Clark?
Well, the only thing I'd say, Your Honor, is I think that was filed and Mr. Riley was set for that final plea calendar, I believe the 14th or 15th was when that entry was filed. I obviously did not pay the case any attention as far as trial, preparing that during the interim. I can see if I can be involved in these conversations with Ms. Iqbal because I am familiar with the case.
Well, that's what I was going to suggest. Maybe there's some way you can come to a meeting of the minds when I take a break.
Yes.
well, this case, position 18 is mine. It's
Mhm.
not a,
Well, maybe the four of y'all can and do, discuss a global,
because discovery was served to Attorney King, so I don't even know if PD Clark has discovery for that case.
I had it from when I had it previously.
Yeah,
Okay, all right.
yeah. I mean, I'm a reasonable person, perhaps too reasonable.
We appreciate that.
Well,
There's no such thing as too reasonable.
the courtroom's starting to collect some cobwebs over there in the jury box, so I'd say I'm a little too, but I will. Is there anything we need to discuss before I take a break?
Yeah.
We did pre-try that. Okay, I'm gonna go out. Y'all call me when I need to come back.
Sorry.
Ms. Clark, Ms. Clark, hey, do you mind giving defense counsel for the Riley case my work cell phone number so he can call me? The 866613085. Thank you.
Oh, you know what? He's on the
she's
calendar.
actually.
He, his attorney.
Yeah, so I knew she was in another, she's in Dunaway.
Okay, yeah.
Yes. He is on the
Right.
calendar, so tell him she's not leaving. That's,
Okay,
Ms.
yeah.
Rockwell's,
Alright, thank you.
Did I hear say I could get her?
Uh-huh.
Okay, I thought she, let me
told
grab
me
it.
that- Okay, all right.
We're basically waiting on your attorney, so don't wait, okay?
John. John.
Hey, you said it so fast.
Judge, are you on mute? I can't hear you.
Okay. I guess it's Miss Charles's announcement, right? Since the no pros.
Yes, Your Honor, thank you. Your Honor, Mr. Butler stands before you accused in indictment 22 SC 181650. He was indicted in March of 22 on one count of child molestation stemming from acts that were alleged to have been committed against the victim in the summer of 2015. There was a 3-year disclosure in the allegation. The disclosure was made in March of 2018. However, the victim was submitted to a forensic interview, and based on what she disclosed in her interview, an arrest warrant was taken out for Mr. Butler. Since then, the state has made multiple attempts, extensive efforts to connect meaningfully with the victim. She continues to display sort of a marked disinterest in the prosecution of this case. Her communication with the state has been vague and sporadic. And the times that we have been able to make contact and arrange meetings, either by Zoom or in person, she's failed to appear. She hasn't called to reschedule. And we do call to reschedule, she doesn't pick up. And so it is the state's position that in the interests of justice and judicial economy, that we will decline further prosecution of this case, given the age of the case and the posture of the victim.
Okay. Ms. Griggs, I assume you support it.
I do, Judge.
All right. Well, I just signed it. So not a whole lot more to go through. Not like it's a plea. It's a no process. So you're excused. Both of you are excused. I just signed it.
Thank you, Judge. And you already said I'm excused. Thank you so much.
All right.
Thank you, Your Honor.
And Your Honor, can I make an announcement on one as well?
Sure.
This would be on one of Robert Riley's cases. This is on 22 SC 184233.
Yep.
So Ms. Iqbal and I spoke. She needs a few more documents from me. What we're asking is to leave us on the trial calendar, but give us the opportunity over the course of this week to try and work it out, which we think we can. If we don't, I'd announce ready.
Okay. I like that.
Yes, Judge, I
And-
do anticipate that the case will be resolved. I'm hoping that we can, when we report on the 31st, that we can tender in a plea at that time.
And Mr. Clark, along those lines.
I think we would have to, I think we'd still need to be in communications with Ms. Dickball on our end on the case, just to see if there is any sort of global disposition. For right now, in his case, on petition. I'm not sure. I guess what Ms. Dickball's intention is, but right now we stand not guilty. The only thing I'd state, Your Honor, is just solely due to the fact that case, I don't know if I was ready to go to trial.
Well, that's what I'm getting at, because I know that your case is Ms. Clark's case as well. But I'm sure y'all are talking, because the best solution, if you come up with one, would be a global one. So what do you want to do, Mr. Clark? You're saying to take it off the trial calendar, yours at
Sounds
least?
like Mr. Riley's gonna be here on the 31st, one way or the other, so I can explore. I think if we're in a position where on our case, we can't reach a resolution and we are just going to trial for whatever reason, I would ask that it be set from that point. I think that's the position I'm in. Suppose we get something resolved.
Okay, Ms. Clark?
Your Honor, I think it's with this case, the state is willing to run whatever sentence concurrent with this other case. However, being that I think I spoke with 88 Iqbal, and she said that some of the charges may change as it relates to that case. I don't anticipate that happening with the case that I have. So, we can reset it till Thursday, but if it goes to trial, it'll need to be reset.
All right, well, we'll leave it on the trial calendar then.
Sounded like 4 different lawyer answers.
I have no idea what any of this means, other than we'll just leave it on the trial calendar for
I
now.
prefer it be reset to like October, but.
Well, I've got one attorney. Look, Mr. Clark has already said he's not prepared. I'm not going to make him go to trial on it. But it's going to be here with King anyway. And so if there's an opportunity for a global settlement, I'm all for it. So,
Yeah, so I'd ask that we just stay to the 30.
Yeah.
See where that, I mean, my client's out on bond anyway, so see where we said, and then we can all discuss it at that point. But I would be ready if had to be on this trial calendar, Judge.
okay.
Okay.
1 minute here. Yeah, you're excused, Mr. King.
Mr. Riley wants to know if he's excused.
He is. Give me 1 minute. I'm trying to keep track of all this stuff. Okay. What did you want to talk about, Kathy? Okay. Any word from Hornsby Wilson or Rockwell yet? Yeah, if you could check on him. All right, go ahead, Mr. Brown.
Yes, Your Honor. Again, I have pre-tried the case with ADA Clark. I renew my request for the case to be further notice to the next final plea calendar. I need more time to discuss the state's offer with my client. And I just didn't feel like I had enough time this morning. And being so new to the case, I just don't feel like it would be fair to my client to try to discuss the state's offer in such a short amount of time. So I again request that the case be further notice to the next final plea calendar. If it could be further notice to the October final plea calendar, Your Honor, that'd be sufficient time.
All right, here's what I'm going to do. So it's just simply your, when were you assigned to it, Mr. Brown?
I filed my entry on May the 21st, so I must have got the assignment like a day or two before that.
Okay, but your issue is that your client has not had a final plea?
That's correct, Your Honor. I was on leave when the final plea took place. That was August the 14th. I was in Maryland.
Of course, we could do one right now, but you're not ready for that.
That's correct, Your Honor.
Okay. All right, here's what I'm going to do. I'm going to give you a pass to October, but that's it. You either put up or go to trial. So
That's fine, Your Honor.
where's your client? Is he here still?
He's in custody.
Okay. Well, you want to bring, are you going to go back? Have you gone back and talked to him?
I went back to talk to him. I want to talk to him at the FCJ. I don't want to talk to him in the holding cell.
All right.
actually, he has, looks like 2 other cases
I rep,
on the October calendar. So. I'm
indicted
going-
cases,
Huh?
indicted cases?
Yes, sir.
Okay. I know I represent him on several, at least 2 CP cases, so I guess those cases have been indicted.
So what I can do is, I can go ahead and add this case onto that calendar.
Well, let's make sure we have a final plea that's far enough in advance, and I might want to schedule a conference call because I want to make sure that everything is ready for that October day, you know, so we don't, even though I know we're going to have specially set one, even those tend to fall through. So I see you standing there, Ms. Clark.
Yes, sir. So 2 things, Your Honor. First, the case was, this is one of the cases where Eric Johnson was the prior conflict attorney on this case. But the next thing is, the co-defendant in this case, Mikhail Floyd, his case is being reset to November, I think the November calendar, because there is a competency evaluation that is being done. Your Honor, the state does not intend to try these 2 cases separately. So we're asking that this case follow Mikhail Floyd's case. It's an armed robbery, and we have out-of-state witnesses, so we're gonna actually need to have it specially set if it goes to trial.
Mr. Brown.
I have no objection.
I know I just want to be compliant with, you just said. you
No,
want-
no, no. I appreciate the intel. I mean, the problem that I have, we can get into this, although November will come up to us. I mean, if it, some of these cases have out-of-state witnesses, it's hard to specially set every one of them, but, all right, we'll reset it to November along with Mikhail.
Thank you. That's my only matter, Mayor. Be excused.
You're excused. Yeah, yeah, you're anybody that I might be the only one on the conference call, but anybody whose trial has been reset, there's no need for you to be on that conference call to discuss it. So. Okay, what do we have now? Chance? All right. Yeah,
May I make a brief announcement on position 9, please? Roger Demar.
yeah.
Myself and Mr. Wilson have reached a negotiated agreement that requires that I re-accuse the case. I have the waiver of indictment. I have it drawn up. I just jumped up to the clerk's office, get that new numbers. If I can be excused to go bring that.
Yeah, yeah. Well, I don't know where Mr. Wilson is right now. I mean, he asked me to hold for his report. He's doing something. So,
I saw him outside of Judge Lethbridge's courtroom.
well. This Chance? All right, let's look at Chance. Oh, let me pull up Mr. Chance. Okay, this is 22 SC 182204 Gary Chance, who's present in the courtroom with his attorney, Mr. Clark. And we have Ms. Christina Clark with the district attorney's office, and you have a negotiated plea to present.
Yes, Your Honor, we do.
Go ahead, Ms. Clark.
Thank you. Defendant Chance, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, you put your hand down. Please state and spell your true, correct, and legal name.
Gary, Garry, Lamont, Lamont, Chance, Chance, Jr., Jr.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
28,
What's the highest level of education or the last grade you completed?
high school grad,
Where did you go to high school?
Benjamin Banneker.
Are you able to read, write, and understand I'm sorry.
Benjamin Banneker.
You spell it.
Oh, spell it. Banneker, Banneker.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have been charged with the following offenses? Count 1, aggravated assault. Count 2, aggravated assault. Count 3, aggravated assault. Count 4, terroristic threats. Count 5, possession of firearm during commission of a felony, which the state will recommend a null pros. And the last count, cruelty to children in the 3rd degree.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form and the indictment with your attorney?
Yes, ma'am.
And did you understand the waiver of rights form and the indictment as explained to you by your attorney?
Yes, ma'am.
And is it your decision to waive your rights today?
Yes, ma'am.
And did you sign the indictment where it says a guilty plea also?
Yes, ma'am.
Your Honor, at this time, the state moves to enter both of these documents, waiver of rights and the indictment into the record.
No objection, Your Honor.
So moved.
Defendant Chance, have you had enough time to speak with your attorney about all the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer, Philip Clark?
No, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Clark, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Defendant Chance, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
For aggravated assault, the minimum is 1 year in prison, the max is 20 years in prison. For terroristic threats, the minimum is 1 year in prison, the max is 5 years in prison. And for cruelty to children in the 3rd degree, the minimum is 1 year, the maximum, 1 day, the maximum is 12 months in jail. Do you understand today that you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court?
Yes, ma'am.
For count 1, aggravated assault, an object which the state's recommendation is 10 years probation plus the special conditions of probation as set forth below. For count 2, aggravated assault, the state's recommendation is 10 years probation plus the special conditions of probation as set forth below. Count 3, aggravated assault, the state's recommendation is 10 years probation plus the special conditions of probation below. Both count 2 and 3, the sentences will run concurrent with count 1. For count 4, terroristic threats, the state's recommendation is 10 years probation plus the special conditions of probation below. The sentence runs concurrent with count 1. Count 5, possession of firearm during commission of a felony. The state will recommend a null pros for that. The special conditions of probation are as follows. Defendant will complete an anger management course within 18 months of his date of release from custody, or in this case, it will be defendant will complete an anger management course within 18 months of today's date. Defendant must have a
Wow, see, yeah, what, position 5, you null pros, what about position 6?
position 6. The state's recommendation is 12 months probation to run concurrent with count 1.
Okay,
Defendant must have a mental health evaluation and assessment within 60 days of the disposition of this case, and he must follow all recommended treatment. Defendant is not eligible for non-reporting probation until after he completes his anger management course requirement. The defendant is to have no violent contact with any of the victims in this case. No drugs unless prescribed. Defendant is subject to random drug screens. Defendant must not possess any weapons or firearms. Defendant must be gainfully employed within 45 days from the date that the final disposition of this case is entered. Defendant will provide proof of employment to his probation officer. Gainful employment is a job that provides at least 40 hours per week. Defendant would not be able to petition for early termination of his probation until the end of year 4. Defendant must provide a 2-page letter of apology to the victims in this case, and letter must be handwritten. Letter of apology is due to the state within 10 days that the guilty plea is entered. Is that your understanding of the special conditions and the plea, negotiated plea that you were expecting today?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those counts or sentences consecutively, meaning one after the other?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today? Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
It is the state's understanding that the defendant will be seeking his plea under first offender. So I will go through those. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? Meaning you understand that this means that you could be adjudicated guilty and you could be resentenced up to the maximum possible sentence for each charge in the indictment.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Defendant Chance, is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
And he would be pleading under Alford.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 22 SC 182205, how do you plead to counts 1, aggravated assault?
Just say guilty by Alford.
Guilty by offer.
How do you plead to the other charges within the indictment?
Also guilty by offer.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the felony plea in this case. Had this matter went to trial, the state would have been able to prove beyond a reasonable doubt that on January 15, 2022, officers were dispatched to the Children's Hospital located at 35 Jesse Hill Drive in reference to a domestic dispute. Upon their arrival, they spoke with Ms. Kashal Martin and her son, Caden Martin. Ms. Kashal stated that she was babysitting her granddaughter at her home outside of city limits, and and the child tripped and hit her forehead while on the bottom steps of her home. Ms. Kashal Martin got her son and her granddaughter, Gianna Chance, and put them in the vehicle and drove to 1975 Rambling Drive to pick up the mother, which is Keisha Martin, of her granddaughter. While at 1975 Rambling Drive, the father, which was the defendant, and the father of the minor child, Gianna Chance, came out to the vehicle and was upset that his daughter was injured. The defendant began to yell and become very irate. Ms. Kashal Martin and Mr. Caden Martin told officers that the defendant pulled out a small tan in color handgun from his waistband of his pants. The defendant was said to have racked back the slide of the gun. Then he pointed the gun at the occupants of the vehicle, to include the minor child, Gianna Chance, Keisha Martin, Kashal Martin, and Caden Martin. At the time, they were unsure what the defendant was yelling about, and the two juveniles began to scream and cry at the same time. Officers also spoke with the girlfriend of the male suspect and was given the same information about the incident. Officers contacted the DV unit investigative team and gave her the information about the incident. Officers also were able to identify the male suspect, the defendant Chance, with a picture that was shown to officers by the girlfriend. The defendant does have dreadlocks dyed a bright green color. The defendant is said to live at 1975 Rambling Drive with his girlfriend and their daughter. Officers were told that the male has a phone but contacts everyone using FaceTime. The defendant also talked to his girlfriend while in the officer's presence and stated that he was about to pull up at the hospital. After waiting 30 minutes, the male suspect never arrived. It was unknown if he was still at the residence located on Rambling Drive, but officers did a knock and talk. Sergeant Bauer was notified of the incident and the defendant was arrested at a later date and time. The state will provide the court the defendant's criminal history.
Can't be that lengthy if he's taken first offender.
Yes, you're right. So the defendant has pursuant to a GCIC that was pulled May 22nd, 2023. The defendant has no other cycles of arrest. This is his only arrest.
Okay.
Nothing further from the state.
Mr. Clark, usually I'm pretty good. It was a little bit hard for me to follow the, not offending Ms. Clark. It was just, seems like complicated.
Yes, Your Honor, and the alleged victims in this case, they can proffer is Mr. Chance's girlfriend as well as his girlfriend's mother, and then his girlfriend's, one of her girlfriend's children. His girlfriend, as the court heard, essentially this was a dispute when Mr. Chance's child got injured. Ms. Cashal Martin is his girlfriend. Their child got injured, was brought to Mr. Chance and Ms. Martin's residence. That was then at that point a dispute between Mr. Chance and the child's grandmother. The child's very young at that point in time. I think this was a situation that was highly stressful. Obviously, I think Mr. Chance is here today accepting responsibility for the part that he played in it. I think we have there has been.
I mean, he's taken it offered, so I'm not sure how much.
And what I would say is I think there is a difference as far as Mr. Chance admits that he did have a gun at that point in time. Obviously admits that I think there was a reaction and wish it didn't get to that point, that there has been a history of some sort of dispute and bad blood between Mr. Chance and his child's mother, that I think they've mostly smoothed over at this point, it sounds like. Obviously, he's not going to have a gun as a condition of this. He's not legally allowed to own a gun while he's on this first offender probation. He is, as I stated, he does have a young child with Miss Martin, and they have another child that they're expecting as well right now. So Mr. Chance's main focus is being out and being able to be there, support, raise his children. And we think this is appropriate based on the lack of any sort of history that Mr. Chance has, as well as the fact that he'll be enrolled in an anger management program. He's only going to be eligible to have that probation terminated once he completes the anger management program.
Well, I think the way that it's written is that he'll be eligible for non-reporting, but I think Ms. Clark has in there that he's not going to be able to apply for early termination until 4 years, correct?
That's as the terms of the offer, yes.
Yeah.
That's going to be, he's going to have those conditions satisfied before termination anyways,
Yeah.
as far as what I discussed with Mr. Chance. So as far as the supervision, that is correct. There's an additional incentive for him to complete the anger management course, other than it being a condition, is that if he wants to get on unsupervised and focus on working and providing on his family mainly, he needs to get that done. And I've spoken with him. He's more than happy to do so.
One of the special conditions, no contact with the victims.
Is no violent
Violent
contact.
Okay,
Contact.
okay,
Yes.
all right,
So-
all right. That's what I was getting at.
And the only other thing I would take note of, Your Honor, and I didn't catch it until we were doing the plea, but I think count 4 needs to be amended. It's 10 years probation, 5 years is the max on terroristic threats. But otherwise, I imagine it just needs to be amended to 5 years to be a legal
Oh,
sentence.
yes, 5 years.
Mhm.
There was an oversight on my part.
All right.
And Your Honor, other than that, we're just asking the court accept the plea.
What sort of work does Mr. Chance do, or?
I believe you're looking for work right now. Is that right?
I'm actually employed already. I work in the food industry.
Okay.
Well, I work at a restaurant right now, but that's what I've been doing mostly my whole life. Every job I work either as a line cook. I've been a manager at multiple restaurants, but that's mainly what I do. I work with food as a chef.
You know, So aggravated assault, that carries a max 20 years, right?
That's correct, Your Honor.
I mean, so that's my only, I mean, I know you've gone over it. I'm sure Mr. Clark's gone over the pros and cons of the first offender, but he's going to be on probation for at least 4 years and just want to make sure that he understands. Now he's 28 years old and has no criminal history.
Yes, Your Honor.
And so that's what first offender is designed for. Hopefully this is just an aberration and Mr. Chance will go on leading a peaceful life and not getting in trouble. But I do want to make sure he's aware of the fact that, he's facing some really big charges here. If he does stumble, it has to come back in front of me. I mean, you got 20 years. I mean, it could be, you understand all that, Mr. Chance?
Yes, sir, Your Honor.
And again, yes, Your Honor. And I've explained that to Mr. Chance. And again, as he sits here before the court with no prior arrests, we do think this is just a blip and he's going to be able to continue to live the life he was leading before this happened.
Well, that's what I hope as well. And like I said, at 28, and not having a criminal record, I'm going to be optimistic about it. But I just want to make sure you understand for your own good, Mr. King. Now, of course, the positive to it, people say I always focus too much on the negative. The positive is, of course, you complete all of this successfully, and you will not have for all intents and purposes, especially when it comes to applying for a job, you won't have a conviction on your record. So, like I said, I think this first offender is designed for somebody like Mr. Chance. So let's get on with it. Second here. Mr. Chance, do you understand the nature of the charges against you?
Yes, sir.
You have just heard from Assistant District Attorney Clark explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement? I can sentence you as I deem appropriate.
Yes, sir.
Although you are not admitting guilt, you decided as in your best interest to plead guilty because at trial the evidence presented against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes, sir.
Mr. Clark, you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I am.
Okay, the court finds that you, Mr. Chance, understand it, the nature of the crimes and the consequences of this plea. There's a factual basis for the plea and the defendant has knowingly, intelligently, and voluntarily entered this plea. Defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended negotiated plea. So that will be count 1, 10 years probation, count 2, 10 years probation, count 3, 10 years probation, count 4, 5 years probation, count 5 will be no prost, and count 6 will be 12 months probation. And all of that will be served concurrently with each other or to count 1. You are to complete an anger management course within 18 months of today. You're to have a mental health evaluation within 60 days and file the recommendations. You will be eligible for non-reporting probation after you've completed the anger management and after you've completed the anger management course and the mental health evaluation. You are to have no drugs without a prescription, no violent contact with the victims, no weapons, especially guns. You are to be gainfully employed within 45 days, and gainful employment is defined as at least 40 hours per week. You cannot apply for early termination of your probation before 4 years. You're to write a 2-page letter. How does that work? Because you said you were going to submit it to the state within 10 days. So you're going to send a copy to both. You're going to send it to the state, and then we're going to track down the people it's supposed to go to.
I mean, I don't know if you can submit it to probation potentially.
Ms. Clark, how do you want to do that?
He could either submit it to probation or he can submit it to PD Clark and PD Clark can forward it to me. You rather probation?
Matter, like, it don't matter.
Okay, I mean, it doesn't, yeah, I mean, if, I don't know when his report date is gonna be at probation necessarily, maybe it just makes more sense for him to send it to me and then me pass it on to the state, so.
Okay.
Okay, how, I mean, so they're gonna send it to you and then we're gonna forward it to,
If
The
he can send
victim?
it to me, I can forward it to Miss Clark and that should,
and she'll forward it to the victim?
Yes.
Okay, all right, we'll do it that way then. And I believe that's it. Is there anything else, Ms. Clark?
No, Your Honor, it's not.
Okay. All right, Mr. Chance, you're excused. Good luck.
Thank you.
All right.
just hang out. No. She's gonna- Yeah. Yeah. Mhm. Sorry.
Oh, that's right. Yeah, probation needs to talk to Mr. Chance.
Yeah.
All right, I see Mr. Wilson just came in.
Your Honor, that concludes my business, maybe.
You're excused.
For position 9,
Yeah,
I know we will have a negotiated plea on that. He is waiting to, he hasn't gotten on the Zoom yet, but he was waiting for me to get here to be on.
okay. That's right.
Okay.
That's right.
That's perfect. We've already filled out the waiver of information, so I can just get him on. When she gets back. we can do that. Position number
And
13.
Mr. Wilson, position 25, that was reset from last time because I have to get you that evidence. Antonio Lewis.
Is that what we're gonna do? We're resetting that case?
Correct, to get you the evidence. That was my understanding.
What position is this?
Fine, well, we're talking about two different positions. Let's
Oh,
go-
sorry.
Wait a minute. So, all right, so we've got DeMar, we're waiting on Charles with the paperwork.
Yes, Your Honor. Moving to 16.
Okay. All right, so 16. That's the one that you're waiting on evidence for?
No, that's position 25, Your Honor. Antonio Lewis.
I don't.
No, Antonio Lewis is 16. This is a revised
Oh,
trial.
I'm
calendar.
sorry.
Okay.
I have the wrong
All right,
number.
all right.
I apologize.
I wish we had 25 positions right now. Position 16.
Yeah, that was the one, Your Honor, we asked to reset so I can get him the evidence.
Well, let's let Mr. Yeah, I mean, I think we reset it due to evidence, but Mr. Wilson, I mean,
Yeah, no, that's it. I mean, this is a pretty key piece of evidence from the discovery that was sent to me already. This outstanding piece of discovery is the only thing that mentions my client. So I think it's pretty important.
Yeah, and we
Okay.
spoke about this, Your Honor, last week as well. So I'm getting everything. I've requested it to get this moved as quickly as possible.
okay, because we need to get that going to trial then if not, but yeah, so we reset that. No. I've got that crossed out. So what else do you have on the calendar, Mr. Wilson? Is that it?
It would be position number 13. So Mr. Thomas, from my understanding, was put on judicial hold at our last, because he was the one who he showed up, we were gonna take a plea, and he has not showed up since. So I was a little confused why he was on this particular calendar, just because I've had no contact with him whatsoever. And the state did ask for a bench warrant and bond forfeiture at the last court date.
Is that what we got on him, Kathy? All right. Let's see here. Yeah, I said do a bench warrant. Yep, I see it right here.
I anticipate being on trial the week of the 11th. I mean, I think, and I don't know how long it's going to take to get this requested information. I think that October would be fine, just to make sure that we have everything, and that we either have a resolution or we're going to trial on this particular one.
All right. All right. Obviously, I've already said it, but we'll need to go to trial if it's not ready next time. Yeah.
It's October 2nd.
All right, so you're gonna wait on Charles, Mr. Hornsby Wilson. All right, okay. All right, what position is Rockwell on? All right, let's go with Ms. Rockwell. Ms. Rockwell. Hello.
So sorry, Judge. I'm in Gwinnett County now. I just finished up. First, thank you for letting us appear like this. I know one of my clients, Judge, has shown up in person, and I think the other one might be on Zoom. Is that the case?
All right, so which one are we doing right now? Okay. So this is position 7, Mr. Davis. Ms. Rockwell?
Hi, Judge. Judge, I need to talk to the prosecutor very briefly about Mr. Davis. I know that she has made a different offer to me. We spoke briefly, and Judge, may I let me see, is she in the chat? Is that something I can speak with you about, Ms. Clark?
Let me sign on to the, Zoom, so then you can send me a chat. I'm signing on now.
Okay.
All right.
And Judge, on Maceo Usher,
Yeah.
that's my other one. He's actually present in the courtroom.
Where is he?
I need to talk to him. He should be in the courtroom. He should be standing up.
I see him.
And, okay, I need to speak with Ms. Clark about that one too. Tell me, could I just stand down for a second? Because I'm going to be in a text, in a chat with
Yeah, you
with
can. You
Ms.
can.
Clark. Thank you so much, Judge.
What do we have left with you, Miss Jones?
I've got Mr. Hodges and Mr. Walker.
Okay.
Can you take Iqbal's case right now?
Yeah.
So, because I'm conferring with Ms. Rockwell. on this.
All right, yeah.
We do have a plea, Your Honor, yeah.
Oops, sorry.
Thank you, 88.
Okay, so this is Iqbal's. Okay.
Rasheen Walker, is that right?
Yes. Where's Mr. Walker? Come on up, Mr. Walker.
What's that? And Ms. Iqbal, this is an Alford plea.
Okay,
Okay, so this is 22 SC 182223. Rasheen Walker, who's present in the courtroom with his attorney, Ms. Jones. And we have Ms. Iqbal, who's on Zoom with the district attorney's office. Ms. Iqbal, you've got a negotiated plea to present.
yes, Judge, I do.
Okay, go ahead.
Great, thank you, Your Honor. Sir, please raise your right hand. Do you swear or affirm that any evidence or testimony you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state and spell your true, correct, and legal name.
Rasheen Walker, Rasheen, last name Walker, Walker.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol, sir?
No, ma'am.
Is there a medication you normally take that you have not taken today?
No, ma'am.
How old are you?
42,
And what's the highest level of education you've completed?
high school diploma.
And are you able to read, write, and understand the English language?
Yes,
And do you understand that you've been charged with the following offenses of 1 count of aggravated stalking and 1 count of aggravated assault?
yes,
And do you understand that you have the right to plead either guilty or not guilty to these charges?
yes,
You understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial.
yes,
Have you had an opportunity to review the waiver of rights form and the indictment form with your attorney?
yes,
And did you sign both of those forms?
yes,
Your Honor, at this time, the state moves to tender in the waiver of rights form and the indictment form into the record.
So moved.
And sir, have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to these charges?
yes.
Would you like any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with your lawyer services?
Yes,
Counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment, including any with respect to his name?
We do.
And sir, has your attorney advised you the minimum maximum sentence for each charge that you're pleading here today?
yes,
You understand aggravated stalking, the minimum is 1 year, the maximum is 10. Aggravated assault, the minimum is 1 year, the maximum is 20.
yes,
You understand today that you're entering a negotiated plea of guilty, which means that the state and the defense jointly recommend the following sentence to the court. Your Honor, for count 1, it's a 5 years to serve 1, commuted time served, balance on probation, special conditions of probation, must complete a family violence intervention program and have no contact with the victim. Count 2, 5 years to serve 1, commuted time served, balance on probation to run concurrent with count 1. Sir, do you understand that's what the state is recommending to the court?
yes,
You understand the court is not required to accept the state's recommendation, that the court has the right to sentence you to the maximum sentence on each charge and run those consecutively, meaning one after another.
yes.
Are you currently on probation or parole?
No,
And do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
yes,
You understand that if you're on probation, you must follow all the special conditions of your probation?
yes,
And do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation for the balance of that sentence?
yes,
And do you understand that you're not allowed to possess or use a firearm while on probation?
yes,
And sir, are you a United States citizen?
I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes,
Do you understand doing so will result in new criminal charges for which you could face a sentence of between 1 to 10 years?
yes,
Do you understand that pleading guilty to a felony, you also may not use a firearm in crime in the future?
yes,
Do you understand that if you were to use a firearm in the commission of a crime in the future, you could face up to a 15-year custodial sentence? Do you understand that, sir?
yes,
Do you understand that by entering a plea of guilty today, you're giving up, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Do you understand that, sir?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
And are you entering your plea pursuant to North Carolina v. Alford?
Yes.
And are you pleading guilty because you've decided that's in your best interest to do so?
Yes.
And are you aware that even if you did not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes.
As to indictment number 22 SC 182223, how do you plead to the charges of aggravated stalking and aggravated assaults?
Guilty by Alfred.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
And do you understand that if you wish to file a challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today's date to file that petition?
Yes.
Your Honor, had this case gone to trial, the state would be able to, apologies, one moment. Here it is. State would be able to prove beyond a reasonable doubt that on April 30th, 2021, officers responded to a fight call at 404 Corvair, Corvair Drive Southeast, which is located in Fulton County. At that point, they made contact with the victim, Miss Kamisha Hodges, Quamisha, Hodges, Hodges, and she advised that earlier that day she had gotten an argument with the defendant, and during the argument, the defendant, he grabbed her around her neck region with his hands and he threw her on the ground. She did have visible scratches on her neck, Your Honor. And then as well, Your Honor, the aggravated stalking comes from, he had a pretrial release bond where it was a CP case 20 CP 194498, which basically, Your Honor, had a no contact violation, which he violated. This defendant, Your Honor, does have some criminal history. One moment. Yes, he has, and they're older, Your Honor. I see some car theft, entering honor from 2006, theft by property 2010, also a financial car theft 2020. I've got some older marijuana charges from the 90s, Your Honor, and entering autos from the 90s as well.
Okay. Ms. Jones?
Thank you, Your Honor. As indicated, this is an Alfred plea. My client does dispute the allegations contained therein. However, he and Ms. Hodges do have some history together or some prior difficulties, which I think the state could potentially introduce at trial. My client has decided it is in his best interest to go ahead and take the state's offer today, Your Honor. We would request that his probation fees be waived for the first year, given the fact that he's got to do the family violence intervention classes, Your Honor. My client does work. He works at Max's Pizza. They do share 3 children together, which he does try to support. And he's fine with the no contact. He can go through her mother to arrange for visitation, Your Honor.
And Judge, I have no objection with the waiving of the probation fees.
So there's a no contact already in place?
There has been, I believe it's probably a condition of his bond currently.
Yes, but that case that I was referring to, Your Honor, it has subsequently pled out and it's a no violent contact from that case, the 20 CP case.
Okay.
So, but we're asking for no contact to avoid this happening again.
Okay. When can he finish the family violence intervention program, Ms. Jones?
This week.
I think we can probably put on, he has to start it within 60 days.
And complete within a year?
How many classes?
Yeah, I think that would work, Your Honor.
All right. Okay. Mr. Walker, do you understand the nature of the charges against you?
Yes, sir.
You just heard from ADA Iqbal explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes,
Do you understand the court is not now bound by the recommendation of the plea agreement? I can sentence it to you as I deem appropriate.
yes,
Although you are not admitting guilt, you've decided that it is in your best interest to plead guilty because at trial, the evidence against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
yes,
Ms. Jones, are you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for earning the plea?
I do.
I find there's a sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I'll accept your guilty plea and sentence you to the recommended negotiated plea as follows, which is on count one, the aggravated stalking, 5 to serve, 1 commuted to time served, balanced on probation. And then count 2, the aggravated assault, family violence, 5 to serve, 1 commuted to time served, balance on probation. And those are concurrent.
Mhm.
Yes, Judge, concurrent.
1 and 2 will be concurrent. You are to complete a family violence intervention program within 1 year. You have no contact with the victim, and your probation fees will be waived for that year that you are taking the family violence intervention program. Anything else?
Not from the defense.
Not from the state, Your Honor.
Okay, you're excused.
And Judge, if we can we, Ms. Jones, stay around? I want to make that announcement on Porter, if we can.
Oh, yeah, and Mr. Walker, probation needs to talk to you. I keep forgetting to mention that.
And so, Judge, can we make an announcement on Daryl Porter?
Let's see. Okay,
Judge, I just received some new information and evidence from Ms. Jones. I was wondering if we could have a short recess, not a reset, not for this week, but like, don't you have a date in September that we could very quickly get on the calendar for final plea and likely resolve it? I'm very optimistic, Your Honor.
Yes. I did provide her some text messages this morning that my client provided to me today that I hadn't received. Currently, the state's recommendation is a 6-2 with talks of maybe the detention center. But given the nature of these texts, along with the body cam, they may change that offer.
That is correct, Your Honor.
all right, well, we've been working offers with them, I see, since June.
And again, we have an offer, like I gave an offer, I've even reduced it down, Your Honor. And if these texts come to what I think that they will, it may be reduced even more.
When are you, so you're optimistic it's gonna plea?
Isn't there like a September 5th or September 10th date, Your Honor?
No, I know, but I
just need time to talk to the victim, review what I received. That's all, Your
yeah,
Honor.
there's just somebody on my other shoulder saying we can just deal with this on the trial day.
Well, I
but,
already have documents to review on the trial for prior to the trial date for another case. Remember Riley, Robert Riley?
Oh, yeah. That's supposed to get resolved too.
Yeah. And I do have information that I haven't independently confirmed that the complaining witness is currently in the hospital.
Oh, I didn't know that.
Hmm. All right, only because I don't want to waste y'all's time preparing for the trial if it's not, but what you saying, the 10th we could do, the 10th or the 11th on September?
Either one, Your Honor, whatever one works for best for you.
11th or 12th. All right, let's do the 11th.
Okay. September 11th.
That's it, though.
Yes, Judge.
What? All right. Is that it for you, Miss Iqbal?
I believe so, but I can stay around just in case.
So what do we have now? Are you ready to do Hodges now, Miss Clark?
If I have to have 2 minutes, Your Honor,
Sure.
I'll be ready.
So we got a big calendar in September, right?
Yeah, I got a trial. You told me I'm first out.
Well, we'll see. You're gonna be up there.
And you've got a trial in October, Judge.
That's what y'all tell me every month, you know?
No.
but,
You've given me an advance date.
got-
I've already
I
started.
got
subpoena-
3 lawyers in this room that have never done a trial in front of me.
Oh, that's true. I haven't tried a case in front of you.
You've never done one. Miss Clark and Mr. Hornsby Wilson.
Well, October will be for me.
He's leaving me envious that he says that he's doing a trial in another courtroom, so.
88 balls of legendary.
Iqbal's legendary in trial?
Oh my,
like
no, I don't know about all that now, Judge.
I'd like to experience that.
I've been told.
Oh no, Judge. Oh no.
I believe it though.
I'll
Telling
reserve-
lies.
I'll reserve judgment, no pun intended, until the trial.
Fair.
The person that said it is, doesn't give compliments easily.
Oh,
Mm.
okay.
What, who said what?
I said the person that told me that doesn't give compliments easily.
Oh,
Right now, all I know is you're legendary at pleas and getting continuances, so.
oh, thanks, Judge. Thanks. That makes me feel real good.
That'll make you feel bad, doesn't it?
That's 4 lawyers now here that have never done a trial in front of me. So I'm just hazing the lawyers for.
But we do resolve a lot.
You do resolve a lot. You do resolve a lot. Well, I was expecting you'd say, well, some of it's my fault for continuing them, but. We got to figure out with Spears. What position is that?
11.
Yeah, I. Hey, Ms. Iqbal? Well, anyway, we're doing a bench warrant on Tucker. We gotta figure out what we're gonna do with Spear, whether that's gonna stick with Brantley or whether I need to do that.
Apologies, Your Honor, I stepped away for 2 seconds to get some water. Yes, Judge.
Isn't Tucker,
Yes,
yours?
bench warrant.
Yeah,
Yes.
you're gonna prepare that for me?
Yes, Judge, and I'll get that to you today.
We gotta figure that out. At least that trial did go,
Oh.
the
okay.
conflict. That would have been a knife to my heart if it hadn't. You know, Brantley sat in my chambers the whole week. I learned a lot from him. Well, he told me a lot. He'd probably say I'm still not learning.
Where was he? He's a retired judge, right?
Yeah, he was in Cobb a long time ago. And then I think he well into his ability to get senior status, he ran for Supreme Court, I think, if I'm not mistaken. And he now does senior judge work all over. Very, very smart, very good. All right.
You guys.
Who are we doing? Are we doing, who has Hodges? Is that Rockwell? Where's Miss Rockwell? Oh, Jones has Hodges. Okay. What's your announcement, Miss Rockwell?
I just sent, Madam Prosecutor a text message and I'm trying to get, a conversation right now with Mr. Roderick Davis. So I'm listening, but I'm signing in and out and all that.
Okay, well, that's great. We're gonna do a
Thank
plea
you.
with Miss Jones and Miss Clark right now.
Thank you, Judge.
All right. So this is, what position is Hodges? It's 5 here. Okay, so this is 22 SC 184471. Mr. Leonard Hodges, who's present in the courtroom with his attorney, Miss Tanya Jones, and we have Miss Christina Clark with the district attorney's office, and you have a negotiated plea to present, correct?
That is correct, Your Honor.
All right, go ahead, Miss Clark.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yeah,
I didn't hear you.
yes.
Okay, you can put your hand down. Please state and spell your true, correct, and legal name.
Name Leonard Hodges, LNARD HODGES.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No,
Is there a medication that you normally take that you have not taken or been given today?
no,
How old are you?
63,
What's the highest level of education or the last grade you completed?
12,
Where did you go to high school?
Fulton, West Fulton High School.
Are you able to read, write, and understand the English language?
Nope. No, I can't read.
My client cannot read or write very well, but we did go through all of the paperwork. I read all of the questions to him.
Okay. Has your attorney gone over all the documents with you so you're able to understand the nature of these proceedings and the charges you're facing?
Yeah,
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault strangulation. Count 2, criminal trespass.
yeah.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yeah.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yeah.
Have you had an opportunity to review the waiver of rights form and the indictment with your attorney?
Yeah.
And did you understand the waiver of rights form and the indictment as explained to you by your attorney?
Yeah.
And is it your decision to waive your rights today?
Yeah.
And is it your decision to enter a guilty plea as indicated by the indictment that was signed today? Your Honor, the state moves to enter both the waiver of rights form and the indictment into the record.
Yeah.
So moved.
Defendant Hodges, have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer, Tanya Jones?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Attorney Jones, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Defendant Hodges, do you remember being arrested on these charges?
Yeah.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yeah.
The minimum is 1 year in prison. The max is 20 years in prison for aggravated assault strangulation. For criminal trespass, the minimum is 1 day in jail. The max is 12 months in jail.
Yeah.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court?
Yeah.
For count 1, aggravated assault strangulation, the state's recommendation is 4 years probation. For count 2, criminal trespass, the state's recommendation is 12 months probation, sentence to run consecutive to count 1. The special conditions of probation are to stay away from the incident location, no contact with the victim, Tykeisha Edwards. Is that your understanding of the negotiated plea terms?
Yeah.
Do you understand that the court is not required to accept the state's recommended sentence?
Yeah.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yeah.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yeah.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Mhm. Yes, ma'am.
Are you currently on probation or parole?
Nope.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yeah.
I didn't hear you.
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yep.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yep.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yep.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yep.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yep.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision, Defendant Hodges, to waive these rights, which means not to use them, and to enter a guilty plea today?
Yeah, no, go ahead.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty
No.
plea?
No,
Is it your decision to enter a guilty plea because you are in fact guilty?
We're pleading by Alford.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
yeah,
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
yeah,
As to indictment number 22 SC 184471, how do you plead to the charge of aggravated assault strangulation?
yeah,
How do you plead to count 2 of the indictment, criminal trespass?
guilt,
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
yeah,
Do you understand that you only have a limited right to appeal this guilty plea conviction?
yeah,
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
yeah,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
yeah. Can you break that down for me? That Haber's bottle too.
I
You
can make
can
that
give
down.
it to me, okay?
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yep,
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
yep,
At this time, the state will provide a factual basis for the felony plea in this case. If this matter had went to trial, the state would have been able to prove beyond a reasonable doubt that on November 10th, 2019, at approximately 6:24 PM, MARTA officers were flagged down by patrons in the bus loop at Hamilton East Homes MARTA station in reference to a physical altercation taking place. Upon their arrival, officers saw a physical altercation occurring between the defendant, Leonard Hodges, subsequently identified as such, and the victim, Tykeisha Edwards. Tykeisha spelled Tykeisha. Edwards is the last name. A few moments prior to the aforementioned altercation, MARTA officers had issued Defendant Hodges a notice to depart MARTA's property as he stood smoking a cigarette in a non-smoking area near the entrance located near to the east side of the station due to him being disorderly and using abusive language while under the influence of alcohol. Defendant Hodges remained on MARTA property, went to the bus loop and boarded bus number 7010-1655 and engaged the victim in a verbal altercation as confirmed on CCTV surveillance. Defendant Hodges then proceeded to choke the victim by placing his hands around her neck. Defendant Hodges was detained by placing him in handcuffs to the rear, double locked and escorted to the police staff room without incident. Detectives were notified of the incident and confirmed that the defendant choked the victim by way of watching the CCTV surveillance footage. MARTA Police Communications ran a check on Defendant Hodges through GCIC, NCIC, which revealed no warrants. MARTA Police Communications also ran a MARTA suspension check of Hodges, which revealed no active MARTA suspensions. Hodges was issued MARTA suspension number 35290 for 365 days, effective 12/10/2019, and he may resume riding MARTA on 12/11/2020. Defendant Hodges was charged with aggravated assault, criminal trespass, and he was transported to Fulton County Jail. Tykeisha Edwards's mother was contacted and informed of the incident since Tykeisha is an actual juvenile. Tanisha was unavailable to come pick up Tykeisha, so Tykeisha's grandmother Sharon Edwards, date of birth 08/03/1965, arrived and took custody of Tykesha. Defendant's criminal history, Your Honor. Pursuant to a GCIC that was pulled on August 3rd of this year, the defendant has a total of 27 cycles of arrest.
Can I say something?
Ask your attorney. Talk to her.
He has misdemeanor convictions in the past for DUI and simple battery out of DeKalb County. He pled under first offender for violation of the Controlled Substance Act in 2017. There's a criminal trespass conviction, which is an older conviction in Fulton County State Court, 2003. Nothing further from the state, Your Honor.
Okay, Ms. Jones.
Thank you, Your Honor. My client does dispute what actually occurred. I've looked at that video as well, Your Honor, and you can tell that they're both in a verbal dispute. My client does look like he places some hands on her and she gets back up and she hits my client a couple times as well. He has decided it's in his best interest to go ahead and take care of this today. And I will note that Ms. Edwards is currently in Fulton County Jail on a variety of charges. My client is disabled, Your Honor. So we would request that his probation fees be waived or at least reduced because he is on a fixed income and he's going to have a hard time paying probation fees. And that's all I have, Your Honor.
Where's West Fulton High School? Did you say West Fulton High School?
Yes, ma'am. Yes. I down on Fulton Dusty. That is the way. That's the old
It's no
school.
longer there. I was just curious about it.
Yeah, it's old school,
Old school, huh?
old school.
All right.
They haven't tore it down now.
Oh, yeah?
They haven't tore it down, and put a new one there.
All right. All right, Mr. Hodges, do you understand the nature of the charges against you?
Yeah.
All right, so you just heard from Assistant District Attorney Clark explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes,
You're saying the court is not bound by the recommendation or the plea agreement. And I can sentence you as I deem appropriate.
yes,
Although you are not admitting guilt, you have decided that it is in your best interest to plead guilty because at trial, the evidence against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yeah.
Ms. Jones, you satisfied that your client's competent in understanding that the plea is voluntary and that there is sufficient factual basis for entering the plea?
I do, Your Honor.
But I find there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I accept your guilty plea and sentence you to the recommended plea, which is count 1, 4 years probation, count 2, 12 months probation. Did you say that was consecutive?
Yes, Your Honor.
It's be served consecutive. You're supposed to stay away from the incident location, no contact with the victim, and given your status, I will agree to waive the probation fees. So you're gonna be on probation for a bit of time, Mr. Hodges. So you're gonna have to be careful and not have another incident like this, okay?
yes.
You understand? All right, anything else?
Not from the defense.
Nothing from the state, Your Honor.
All right, you're excused. All right, who do we have next? So Mr. Wilson, you're sitting there. Oh, that's right. You're still waiting for Charles. Know whether he. And then we have Miss Rockwell. Well, I may take a quick break. I'll be back. I guess call me back when it's time. Okay, Kathy? All right, thank you.
Judge, you not like the haircut?
What?
I like your haircut.
Oh, thank you. Thank you. Yeah. It was time to get one. What? You know, she no respect. No, I'm used to it. I know. Gotta have thick skin. No respect.
Attorney Rockwell, I got your email. I'm gonna work on that right now. I wish he had a said that he wasn't the attorney on this second case. I could have been resolved, that worked that out with Clark. Philip, I mean.
Yes.
Yeah, I think one is gonna be a plea. She's just basically having to I guess, go over it. She said she lost the term, so I need to send them to her by text. We don't want to know. We don't care. It goes to like, their, coherency, so. It goes to their, you know, like they're, whether or not they're present, like, but it's a faculty, so it's very. Good. Oh, I have. At least, you know what I'm saying, it's. So. I'm gonna go see a dog. Oh, it's Takesha. For Congress,
No, I mean before.
Oh, her name is,
But I had it as.
I'm gonna see you the term. I was thinking it email stuff. Oh, wow. Okay. Type it out now. Okay, it's type TY. Yeah. Yeah, capital. Well,
Yeah,
I mean, capital K. TISHA. Oh, it's not in this. She's not one. Stay away from the incident like that.
Yeah, no, yeah, but we're not, now it's. gonna be- Yeah, your child 18, this is what we're- this final. Yeah, we kids have around 6, but I don't think. Well, yeah, 11, 12, final 28. Docket will be 14.
Yeah, you can send us. Well, I'll be here. I mean, but it'll be by the time I'm honest. Yeah. You know what?
Yeah, yeah.
Oh, more.
But I forgot what I was.
So no, but we can count. You know what I did with it? But that wasn't, she had said first offenders. It's probably, what's his name? Michael Smith. Hey, how you doing? Doing good. Hey, I'm still in court waiting for the judge to come back, but I wanted to, this is the one plea I didn't get a chance to go over with you. I wanted to get your thoughts. So it's Maceo Usher, 22 SC 184546.
Christina, you are not muted. I can hear you.
Oh,
I didn't know if you wanted to.
oh, no, I didn't.
Okay. Sorry about that. Sorry to interrupt you.
What are we looking at, Kathy? Is Rockwell on?
Hi, Judge.
Hello.
Well, we have a turn of events. I just put something in the chat. I'm requesting a final plea on Mr. First of all, on Maceo Usher, the October final plea. I'm about to go on leave, Judge, on August the 31st. I'm on the leave, but anyway, I have a phone number and I need to discuss with the victim on Maceo Usher. Got that. Let me pull over, Judge. I'm sorry. The second thing I have, and now I am not driving, Judge. I am stopped. The second request I have.
Well, let's talk about Usher first. So
Okay.
we got, we've been dealing with him, for a while now. We had him down for a trial date this week. What's going on with that?
I did speak with Madam Prosecutor on him, Judge. I do have everything. I have all the discovery, everything I need on him. There has been very recent contact with the victim in the case. Is this something that could be wrapped up by Wednesday, Judge?
Well, who's got this? Clark, you?
Yes, Your Honor. This is my case.
So let's look at the calendar here.
And I can stay over, etc. if that needs to happen. I just we're not far apart on this. He
What'd you say?
doesn't want a felony on his record. But the prosecutor has to take it up the line.
So we've got how much time do you think this case is going to take?
For a trial?
Yeah.
Too many witnesses. There's probably only 2 witnesses.
Well, Your Honor, the state was under the impression that, based on the defendant's posture, that there was going to be a plea today for this case. So, it's not going to be a plea then. The case will, I guess, need to be further noticed.
The problem from my standpoint is, of course, I don't know plea or no plea. We put it on the calendar. Where's Mr. Usher?
He was here.
Judge, he's actually at the courthouse. I can get him to walk back in the room.
I think that's a good idea.
Yeah, let me get him to walk back in the room because I think he was concerned about his Zoom capabilities, so it kind of got him nervous. Let me get him back in the room.
All right. Well, I think they want to talk to the witness for a plea, but I think they're not on the same page with the plea.
Your Honor, can I make an announcement on?
Sure, what's yours?
It's my understanding we now have the accusation number for Mr. Jamar, but we will not, I guess Ms. Charles is in a motion to suppress hearing, and she's not going to be able to do it today. So we ask that you just stay on the 31st calendar. I mean, this is going to be a negotiated plea. We've got everything worked out, but I think given the time it took to get the accusation number and then Ms. Charles having another responsibility in another courtroom, again,
Well, I mean, this
anticipate
is,
being a
I mean,
plea.
I'm a little frustrated with Charles because part of why we've waited around here so long is her. And this motion that she's supposed to be doing, I wouldn't, there wasn't a word said to me about that. I just, I was told that she was going to need to take a few minutes to go down and get this reaccused and be back here to do a plea. So this is, I'm trying to figure out what's going on here.
I mean, obviously, Your Honor, my preference and my client's preference is to get it done today. If that means we have to wait around a little bit, that's fine with us at least, but
Well, the one thing I don't want to do is, just bring a jury in for no reason. Other than we're not ready with something that we are sure we're going to be ready with later.
is there another
Well,
date between?
Ms. Clark, can you reach out to Ms. Charles on this new development that she's supposedly somewhere else now?
Well, Your Honor, actually, I've already reached out to her. That's why we are aware of the fact that she's in the motion to suppress hearing. I had actually contacted her. And she had said that, she'd rather do the plea herself so she can do it on on the 31st.
Yeah. Well, I bet she would, but I mean, I don't know any other way to say it. It's very disrespectful to tell me that I'm going to get this re-indicted and be back in a few minutes and then it just disappear. And now at 1:45, find out that she's not getting the re-indictment and she's off somewhere else.
Well, to be clear, it was re-indicted.
Okay, well, she got the re-indictment and then decided to not come to the courtroom. I mean, I don't really know how that's better. I guess you can phrase it how you want. I don't really understand how it's any better. Where did we go wrong, I guess? I don't know. So she's not returning today. She's just gone.
That's correct, Your Honor. Because she's.
Judge, sometimes I wish men fought over me like judges fought over me sometimes.
Yeah.
Just in defense of Miss Charles, she was probably walking by a courtroom where she always needed to be. And Judge Arrington used to have a deputy put handcuffs on me so I couldn't move.
Yeah.
I just have to stay there. It's not real assuring to a client when the lawyer gets handcuffed to the deputy. But anyway, that's just kind of a.
Well, I just don't
theorized.
like hearing about this at 1:45 when big reason we've been waiting here was I don't know.
Well,
Be nice to get an email or something. That's all, but
ADA Charles, knowing that, the type of prosecutor she is, I don't think it was, even though it could have been handled differently, I don't think it was intentional to.
yeah.
They have just, with her first date being back.
And I've been very understanding of all that.
Right, I got it.
I mean, from my understanding, we've worked out the framework and everything, so I have no reason to believe why it wouldn't be a plea on the 31st.
Yeah, she did say it would be a plea.
Is there,
today. But
is there a date before the 31st, just so I mean, we won't have to technically bring in a jury or?
Kathy, is there any time in between then that we could do this plea? Can we do it that day?
Well,
He's not in custody. So let's do it.
well, yeah, just on Wednesday, if it is to be.
Well,
set
wait a
on
minute
Wednesday.
now. When was the McGee motion filed? But when did we schedule that?
So that. Rockwell's plan.
But when was this put on the Outlook calendar? What's on there now, but has this been on here for a while? Well, no, but I wrote CME out on the calendar.
I don't know if it was on there before or after.
You can leave it because it turns out that I've got a doctor's appointment, but I'll be ready by then. It's at 6 a.m. But why don't we let's do the final plea then tomorrow on the 29th. How about that?
In the morning.
What do we have? Well, the 29th is this trial conference call. That's probably not going to happen. So yeah, why don't we do it at 9:30? Does that work?
And Your Honor, since my client will be appearing via Zoom, may also, and we've already filled out all the appropriate paperwork, or at least the waiver form, and signed that. I've signed that on his behalf. May I appear via Zoom also, since he lives in California?
Oh, yeah, you can. Just do me a favor and just do your best to be on the same page with him. I know, questions can arise and it's their right to talk to you, but it does tend to slow it up when sometimes I've had some pleas where it's clear their defense attorney and their client's not on the same page.
I understand. So you said 9:30 tomorrow?
Yeah,
I'll talk to him before.
yeah, just talk to him tomorrow, see, like I said, if he's, oh, he is.
Yeah, he's listening.
Oh, he's listening. All right. Well, you can tell him to just make sure that you try to get his questions answered, but he's certainly entitled to ask questions. So yeah, we'll continue it till tomorrow, just in case for some odd reason it needs to go to trial. So,
Right.
All right.
Thank you, Your Honor. May we be excused?
Yeah, you and DeMar are excused.
All right, thank you.
Yeah, so what time is it? 9:30 in person? Okay.
I mean, I'll be at the courthouse, but if nobody else is going to be present, then I won't torture the deputies and make them come out for me just to sit here and be on Zoom. So,
All right. I just sent her a text.
okay, tell her that. So, all right. So now let's get back to who are we talking about? We're talking about Usher, right? Miss Rockwell, you there?
I'm here, Judge.
We're back. We're fighting over you now.
Judge, you want me to teach you how to use the Zoom on your phone?
No, I mean, well, teach me how to do it when you're at a stoplight. I'll tell you. Why don't you try that? But
Well, I'm stopped right now. I'm stopped.
all right.
So anyway, is there a way that we can Kathy set up a breakout room with you and Miss Clark and myself?
The three of us.
Yes, sir.
Yeah. Well, we can do that. So you want
And
to talk
y'all-
about Usher?
In other words, well, I want to talk about Usher. I want to talk about Mr. Davis and I want to talk about my leave of absence that I'm fixing to go on. So I don't want anybody to get nervous that I'm talking about them, in vain. I mean, always.
Yeah, I mean,
with
we
fun.
can, I'll tell you what. Why don't, I'll just have Clark come back to my chambers and I'll give you a call on the phone, all right?
Okay, thank you so
All right,
much,
why don't we
Judge.
just do that?
All right.
Whatever to move the wheels of justice,
Your Honor, are you gonna need us anymore today? You think you're gonna take the business?
Are we, so we don't have any pleas left? Okay.
I don't
all
think
right.
so.
All
I
right,
don't think so.
all right, all right, all right, all right.
All right.
Yeah, y'all can be excused.
No, no. we're not allowed.
All
Yes, Judge, I have told her.
That's all right. Tell him he's excused. It doesn't sound like anything's gonna be accomplished on it today. Just tell him to wait here then. I'll be back. Come on back, Clark.
All right. Can you let me in? Yes, Robinson.
Yeah, I gotta go drink a cup of coffee.
Smash that button.
I do like. If they're really cold, yes.
They did a good job with that.
If it's really cold, yes, it tricks me.
Anyway, I'm just saying, you know how I do. What I heard.
I have not heard.
Don't know anybody.
Yeah. Sure. Y'all don't like it here?
No, I like it.
Yeah. All right, so are you Usher? Maceo Usher. All right, so what I'm gonna do on your case is I'm gonna reset it. It seems like there needs to get more information, but this will be the last reset I do. So you just need to be, you need to, I mean, you have two options. You can negotiate a plea. It's your right. You don't like terms to not accept that plea, but then we'll have to go to trial. Okay. And you can plead your case to we can have a trial and let the jury decide. Do you understand that, Mr. Usher? Okay.
Your Honor, if I may, the state would like to put on the record what the offer is.
It's a good idea.
Okay, so Your Honor, for this case, the state offered 5 years probation for the aggravated assault and then 5 years probation consecutive for the possession of firearms during commission of a felony. And on this particular case, the defendant would be eligible for first offender probation. The state will not be offering a misdemeanor on this case at all because there was an actual shooting. So it's either that offer or go to trial.
And just for the record, since we're talking about on the ag assault, that's a 20-year max, right?
Yes, Your Honor.
And then what's the possession of a firearm during commission of a felony?
That's an additional 5 years.
So,
And it has to be run consecutive.
and it has to be run consecutive. So I'm just making sure you understand, Mr. Usher, because we're going to reschedule this for a final plea in October. But when you're talking with your attorney and your attorney is talking to the prosecutor, that ultimately, if this goes in front of a jury and they find you guilty, that you could be facing 25 years. You understand that, Mr. Usher? Okay, just want to make sure you understand all of that. Have the information you need when you're talking to Ms. Rockwell, who a very capable attorney, and when you're discussing potential plea negotiations. Anything else?
Judge, before he leaves, could he get with Kathy to fill out a change of address? Or
He goes to the
Kathy have
clerk's
one of those?
office.
okay,
He goes to the clerk's office.
okay.
I see you
And
shaking your
that's
head.
gonna be the Superior Court clerk,
Pardon me?
the Superior Court clerk.
With who? Yeah, come on up to the podium. Go ahead, Mr.
Your Honor, thank you for letting me speak. I feel like this, I have something here, man. I need to pull it up.
Well, wait, let me just, your attorney's on Zoom right now. Well, if we're going to talk about you getting your address for the clerk, I'm fine talking about that. But if you're going to talk about the details of your case, I'm going to get a little anxious about that because you could say
Yeah.
something that incriminates yourself.
I don't want him to say anything at all.
Did you hear that?
I don't
Miss-
want him to even say he was at the scene.
I'm
Yeah.
not
I don't
speaking on
want him to
that.
say anything.
I'm not speaking on that. What I am speaking on
Okay,
is the lack of communication from the court system where I filed February 21st of 21, my address, and I just get a call last week saying that I needed to be in court for trial. I'm not prepared. And then to be within a month time, a couple of months to get ready for this, I am nowhere prepared for this right now.
Well,
And I just think the communication from the court system, from the lawyers, and it's beyond. I'm not no criminal. I don't get out here and do.
all right. I
I'm
get your
a
point.
businessman. So if I pay good money, I suspect this to be treated.
All right. I get your point, Mr. Usher, but let me, Miss Robinson, what's the issue with his address?
If it was filed, it never would.
Child support found me.
And Judge, that's what he's saying. He did
All right.
go to the courthouse and change his address on a different case. He had a child support case, but that did not even transfer
Okay.
over. And I know exactly why it didn't. So,
Well, I know you're getting frustrated, but it's just we don't do the addresses. You're going to need to, when you're done here, go to the clerk's office and make sure they have the correct address for this case. Okay.
Correct. Right down on the field floor, correct? That's where I went once before and I changed the address.
Yeah, but that was for a different case is
No,
what
it was
everybody's
for
telling me.
this case and a
Well,
child support case.
regardless, I don't want to be callous about it, but you're complaining to the wrong person. It's the clerk's office that doesn't have it correct. So I know you're frustrated, but I'm trying to tell you how to get it fixed. And so make sure go down there, make sure your address is correct. So we avoid this. Stay in touch with Ms. Rockwell. We're setting a final plea in October. So that gives you half of this month, all of September, and then October to figure out whether you're gonna do a plea or go to trial. Okay.
Correct.
All right. All right. So
Thank
just
you.
go down to the clerk's
and-
office and go ahead, Ms.
and
Rockwell.
Mr. Usher, it's not the 5th floor anymore. It's really the 1st floor on the 136 side. If you go to the metal detector on the 136 side, they will tell you where the Superior Court clerk is.
Well. All right. You got to just find a Superior Court clerk. All right.
Understood.
Okay. All right. All right, Mr. Usher, you're excused.
Have your excuse. Thank
You're
you.
excused. All right.
And Judge, I have to get Mr. Roderick Davis back on the line. I don't know if I lost him because I know that he's not on the line right
Well,
now.
I think we're all itching to
Um,
get going. So just tell Davis that
Okay,
he's got one October, but that's it. We're not doing
Yes,
any
sir.
more
final plea.
or
Yes, sir. Thank you,
resets.
Judge.
Okay. All right. All right.
And Ms. Clark, I'm gonna call you as soon as, you just call me as soon as you walk out the courtroom.
Okay, Ms.
Thank
Clark.
you so much.
Yes, ma'am.
All right. Thank you. All right. We're adjourned. What?
Thank you, Judge.
Wait a minute, Mr. Davis is back now? All right,
I'll
Mr.
t- oh, he
Davis, you
signed
there?
back in, Judge. He doesn't, Judge, he doesn't have his audio on, but I'll just tell him, he can hear you. He does not
All
have
right.
his audio
Okay,
on.
well, you can
And I
pass it
will let
on,
him
but
know.
we're gonna reset this till mid-October. I guess for the record, Mr. Davis, you can hear me? Just nod if you can.
Yes.
Okay, well, all right. Well, so why don't you, what's the offer that you got on this one, Ms. Clark?
The offer that was extended by a prior ADA is 10 years to serve 8 in confinement.
Okay, so
Judge,
you got,
that's not the plea offer we signed up for. We had tweaked that. But now we're starting back to scratch because of the new events.
Yeah, so Your Honor.
oh, that's right, that's right.
They had
All
offered
right.
a probationary offer. However, the state rescinded that offer once they got additional
okay.
information about pending criminal charges.
All right, well, so Mr. Davis, you've got until, we're gonna schedule a final plea in October on this, and you've got until then to talk to your attorney about whether you want to accept or negotiate a final plea or take this case to a jury and, deal with the potential of all that. You understand, Mr. Davis?
Yes, sir.
Okay. All right. All right, we're adjourned.
And Judge, I might need you to, Kathy, can you please just tell Tammy Gorman that I'm just getting released from y'all? I'm heading to her now.
Okay, all right.
Thank you so much.
All right, well, go ahead and I know you've got some templates. Just do that grant for Renee on the withdrawal for McGee.